right is Howie Halleck. On his right is Glenn Payne. On his right is Mark Goldfuss. And on his right is Arthur Brown.
We have been talking about the procedure set forth in Section 15 for approval of investment advisory contracts. On the two previous tapes, we have discussed the requirements of Section 15A, and we have just been discussing the requirements of 15C. And Arthur, Sid, and myself have tried to emphasize the importance that the Commission now gives to a thorough review by the disinterested directors of both new advisory contracts and existing advisory contracts in the context of voting to approve continuance of such contracts. That then is the heart of Section 15. However, due to some court cases, in particular one court case, and issues that were raised in the early 1970s as to the proper procedure which should be followed by an investment advisor who, in selling a controlling block of his shares to a successor advisor, or indeed selling his entire business to a successor investment advisor, in the 1975 amendments, Section 15F was added to the statute to try to deal with this sale of an investment advisor problem. And I think it would be good to discuss Section 15F and the history surrounding it for a few minutes. The leading case in this area is Rosenfeld v. Black, which can be found at 445 F. 2nd, 1337. It is a decision of the Second Circuit Court of Appeals, and it came out in 1971. Rosenfeld held that a fiduciary, including an investment advisor to an investment company, may not transfer or sell his office or position for personal gain, and that there is a private right of action to recapture for an investment company any such gain. Now, when this decision came down, it created quite a stir and controversy in the entire investment company industry, because prior to that time, it was fairly customary where a sale of an investment advisor occurred for the preceding advisor, first of all, to recommend to the shareholders of the investment company that the successor advisor continue to perform the role of investment advisor, and for the preceding advisor and not the investment company to keep any gain or profit that might have flowed from the sale of the investment advisory business. Given the Rosenfeld holding that such a transfer should not be effected with the preceding advisor keeping the gain or profit, the industry immediately began to lobby Congress to try and amend one or more of the provisions of the Investment Company Act to, in effect, reverse the Rosenfeld decision. Well, as you can no doubt imagine, when these legislative proposals went before the Congress, the Commission made its feelings felt on the question. And as a result of the desire of the industry to have legislation resolving the Rosenfeld problem, and as a result of the Commission making its position known to Congress on this matter, In the 75 amendments, Section 15F was added to the statute. As passed, Section 15F permits an investment advisor to receive any amount or benefit on sale of its securities, which results in an assignment of the investment advisory contract or a change of control of the advisor, so long as two important conditions are met. So in other words, the industry does get some relief from the Rosenfeld position, but only if it complies with the following conditions. First of all, for a 3-year period after the sale of the advisor's securities or business, at least 75% of the investment company which that advisor advises, board of directors, must consist of persons not interested persons of the investment advisor or its predecessor. So in other words, if you're going to get relief from Rosenfeld, if you're going to be able to take advantage of the 15F safe harbor provision, you will not be able to go on the basis of Section 10 and the 60% requirement, but you'll have to agree to have at least 75% of your directors be disinterested persons. Both of the existing investment advisor, i.e., post-transfer investment advisor, and of the predecessor. And the second condition was that the sale of asset transaction not impose, either expressly or impliedly, any unfair burden on the investment company. Now, as I say, 15F was only added to the statute in 75. So there's not a great deal of interpretation as to what will constitute an unfair burden. However, we do have some guidance on that point. Specifically, we know that an unfair burden will be found to exist if during a 2-year period after the sale of asset transaction, the investment advisor, its successors, or any interested persons of the investment advisor were to receive any compensation from A, any person in connection with the sale or a purchase of securities as property of the investment company, or B, any compensation from the investment company or its shareholders other than the bona fide advisory fee. So in other words, under 15F, if within a 2-year period, the investment advisor or the successor or interested persons receives anything other than the bona fide advisory fee, this, under the section, will be defined to constitute an unfair burden, which will then prevent the company from relying on the safe harbor provision of 15F, which then will obviously throw them back under the general Rosenfeld standard. Okay? Now, as I say, 15F was only added to the statute 4 years ago. So we haven't had a great deal of interpretive work under 15F, but if in your inspections or in your work at the home office, if you do see a transaction that does appear to involve a sale of a controlling block of securities of an investment advisor or an advisory business for a profit, and after the transaction has been effected, the board of directors of the investment company which that investment advisor serves does not constitute at least 75% disinterested directors, then an immediate question should come to mind as to whether or not there's a Rosenfeld problem. Now, again, I want to stress that simply because a fund doesn't meet 15F doesn't necessarily mean they violated any provision of the Act, because 15F is a safe harbor provision. What it does mean is if they don't comply with 15F, then they have to comply with the provisions of Rosenfeld v. Black.
My suggestion to those of you who may be doing inspecting is when there has been an assignment, such as the type that Glenn mentioned, you might look to see what, if any, additional benefits the assignor, the previous investment advisor, may be getting from the investment company. For example, is there a understanding between the new investment advisor and the old investment advisor that the old investment advisor will get a large portion of the brokerage of the fund as additional compensation? Has the old advisor been taken on as some type of a consultant? Now, this may or may not be indicative of an undue burden, but it should be examined in the light of the provisions of that 15F to determine whether it is an undue burden on the fund as a result of the investment, of the sale of the investment contract, because really that's what it is. Normally when these things, when the assignment takes place, the assignment does not take place by a sale as simply as Glenn mentioned, because Glenn was trying to be overly simplistic so that people can understand. What really takes place here is an assignment contingent on the acceptance of the new investment advisor, approving that the new investment advisor will be approved both by the board of directors and by the shareholders. If either of these two conditions are not met, then the assignment is not complete. So that what happens here is that the investment advisor must use its best efforts, and even more than its best efforts, in order to get the fruits of the sale. He must use his best efforts to make sure that both the directors and the shareholders approve the new investment advisory contract. And this is not too difficult, because normally the investment advisor controls the proxy machinery. And I might say in many instances, in determining a controlling influence, who controls a company, one of the big indicators, one of the big indicia, is who controls the proxy machinery. And since in this case, the old investment advisor, the then present investment advisor, controls the proxy machinery, he uses his best efforts to see that the shareholders accept the new investment advisory contract.
Sid, in that regard, there was an early case, I'm not sure that it ever became public, involving requests for our interpretation of whether somebody could rely on 15F1. And without belaboring the point, I think there's an important point to be made about the requirement that you have 75% disinterested directors. In this case, someone asked us, well, first of all, you have to remember this is a safe harbor. This is, the advisors do not accept Rosenfeld v. Black. I think there's still a defense to that, to the judgment there. So it's only if you don't want to fight Rosenfeld again that anyone's relying on 15F. On the other hand, 15F does provide a procedure which it does not appear to be impractical for a lot of people to meet upon a sale of an advisory contract. In the case that came for our review, There was a board of directors of about 6 or 7 directors, some of whom were interested. And the terminating advisor brought to that board 3 new people to replace 3 people who were affiliated with the advisor and would leave voluntarily. These 3 people were basically handpicked by the old advisor, the very point Sid raised. We refused to take no action. We refused to assure that company that they were in compliance with 15F. And even though the face of the statute isn't necessarily clear on this, the point of the legislative history and the reports on 15F, I believe, was that the new directors be selected, and this is something like the Section 16 requirement, that there be selection by the other independent directors, so that where there's really a setup by the old advisor or by the new advisor to get people who otherwise are disinterested, if they're really brought to the board's attention and the board doesn't make an independent selection, I think we'd look pretty hard at that situation. Because what you really want to have here is investment companies in control of themselves, or at least their boards being in control of them, and not their advisors. And if you don't cut through that situation where it's really a setup and everything's just done pro forma, the fund becomes very susceptible to abuse.
Well, I think that we were correct in that interpretation. We don't have to give no action letters, and whether or not this constituted a violation, or I use the word violation. Technically, that's not true because you can violate 15F. But whether or not 15F, under those conditions, would give him impunity to the transaction, I don't think we have to say. But we don't have to go where we have some doubts. It seems to us, in a situation that is prophylactic, in a section of the Act that is prophylactic, we shouldn't be bending over backwards to give somebody impunity through the no-action procedure.
There is an out in Section 15F, though. The section does provide that an application can be filed, and after the Commission reviews the facts, we can permit the investment company to continue to operate without having 75% of its board as disinterested persons. And this out, incidentally, is particularly important in the case where instead of having the investment company switch over to a new advisor and remain as an independent entity, if the investment company is merged into an existing fund by the new advisor, then conceivably the new advisor would have to put up 75% disinterested directors on the existing fund, which would make considerable hardship on the existing investors.
That's a very good point. For example, let's assume that you had a $2 million fund that was limping along, and a $2 billion fund, it merged into a $2 billion fund. And let's assume, as a result of that, the investment advisor of the old fund got some compensation. The question comes up, does the old big fund have to now change its board of directors so as to constitute 75% disinterested directors? And we have been very sympathetic to those situations, and if we haven't given recommended orders, I think we've taken some no-action position. Have we given orders?
We've issued at least 1 and possibly 2.
Yes. Well, there, obviously, the greater company, the benefit of the greater company, the bigger company, surpasses any disadvantage to the shareholders of the small company. At the time of the merger, of course, the people before the merger takes place, and this is not an excuse, but it is a fact, people can redeem their shares in the small fund and walk away. They don't have to go into the merger, and they're not penalized by this because they're going to get their net asset value. The only possibility, of course, is that if they happen to be in a capital gains position, their redemption would be a taxable event, and they'd have to pay taxes. If we're talking about a $2 million company, I don't think we would have too much occasion to talk in terms of capital gains or profit to the investors, because normally any fund struggling around $2 million isn't doing too well.
Howie and Sid make a very important point as to the application procedure that is set forth in 15F to relieve a company from the 75% disinterested director requirement. However, as both Howie and Sid have indicated, the exemptive relief that we have given using this authority has been very, very limited. Indeed, limited to the situation that Sid described, for the rather obvious reason that, there's no abuse or harm in that type of a situation. Certainly, however, I think it's fair to say that the staff of the division is not going to bend over backwards to process applications to give exemptive relief from the 75% test. As Arthur and I noted, this is a safe harbor provision. Nobody requires an investment advisor to comply with 15F. And given the fact that it is a safe harbor provision, we think it's appropriate to apply these conditions quite strictly. That then is the provisions of Section 15F. Are there any questions? And then that then is Section 15 as it relates to the issue of approval of advisory contracts. Before I move on to Section 15B and talk very briefly about the approval of underwriting contracts, let me deal with one other issue in the advisory contract area. That is a problem that we found developing at the latter part of the 1960s. That is, we found a number of investment company contracts with their advisors, including what were referred to as incentive fee provisions. This was simply a provision that, in addition to a basic investment advisory fee, an investment advisor would be entitled to receive an additional fee depending upon the performance of the investment company. And in the late 1960s, these incentive fees began to take a number of forms. And indeed, when we began to look at them, we found that all too often they took the forms of heads I win, tails you lose. That is to say, if the performance was good, the incentive fee would add a significant amount to the investment advisor's total fee. But if the performance was poor, there would be little or no reduction in the basic investment advisory fee. Now, to deal with that problem, in 1970, Section 205 of the Investment Advisors Act was amended to include some specific provisions applying to fees charged by investment advisors, including this incentive fee element.
Glenn, the reason that this, what I call abuse, could take place was that prior to 1970, an investment advisor that advised registered investment companies exclusively was not required to register under the Advisors Act. Under the Advisors Act, Section 205, previous to the amendment, outlawed any incentive fees. The reason why but as I say, investment advisors to investment companies were not included because they were not registered and didn't have to register. The reason for that requirement was that it allows the investment advisor to speculate on the basis of the investment of his client. In other words, so long as he makes a gain, he can get a bigger fee. So the more chances he took, the more gain he took, and the more gain he could look forward to, and if anybody was going to lose, obviously from this speculative activity, it wasn't going to be he, it was going to be the investment, it was going to be the client. So the sharing of capital gains was prohibited previous to the 1970 amendments.
Okay, that's thank you, Sid. That's very true. And indeed, Section 205 starts off with the same prohibition. Section 205 includes a flat prohibition against investment advisors in their advisory contracts basing their fee on a incentive factor, percentage of capital gains, if you will. However, what the amendment did is it gave an exception to this flat prohibition to permit incentive fee contracts with certain entities. Now, one of the entities was registered investment companies. As Sid noted, prior to 1970, investment advisors to investment companies were not required to be investment advisors under the Advisors Act because they did not meet the definition of investment advisor under 202A11. In 1970, the definition was amended to bring those advisors to investment companies under the Advisors Act. Now, to deal with that problem, that is to say, to deal with the fact that subjecting 205 to then investment companies would prohibit all incentive fee contracts, registered investment companies were accepted from that provision. The second exception went to other persons, with certain exceptions which we won't talk about here, where the contract related to assets in excess of $1 million. Okay, those are then the two types of entities that can enter into incentive fee contracts. Section 205 also imposes, however, certain conditions that these incentive fee contracts must meet. First of all, the fee must be compared to the performance of an appropriate index or standard. In other words, the incentive fee cannot simply be some hypothetical computation. It must be determined by comparing the performance of the advisory entity to an appropriate index, i.e. the S&P 500, or standard. Secondly, there must be a fulcrum fee which increases or decreases depending upon whether the fund beats or is beaten by the index. By fulcrum fee, I mean the base fee.
If you look at a seesaw, really, the fulcrum fee is right in the middle, and the incentive fee is on one side. That, in other words, the increase of the fee is on one side, and the decrease in the fee would be on the other. And the board has to be exactly even. If you visualize what we're talking about with the seesaw, the fulcrum, the way the seesaw moves, is right in the middle. That's the base fee. From that fee, it either moves up or it moves down.
Yeah.
So if the fulcrum fee is 0.5% of average net assets, that's the measuring base, is that correct?
That's the measuring base.
That's right. And as Sid indicated, the third specific requirement is that the incentive fee must go down as far as it goes up. Again, the seesaw, it must be equal on both ends. In other words, we want to prevent the heads I win, tails you lose situation from developing.
Say, for example, if it says if they beat the index by 10%, they get an eighth of a point, an eighth of a percentage more than if they are if the index beats them by 10%, they lose 1/8%. And it has to be exactly the same measurements all the time. In other words, if you get an incentive for so much percentage increase, you take a loss for so much percentage decrease, or the fee. In other words, if you lose, you get the same penalty that you would for the same percentage that you would gain.
That's right, and those are the conditions that are built into the statute. Now, subsequent to passage of the amendments of 205, the division has taken a number of interpretations of those statutory conditions. And indeed, at the basic release in this area, that if you have a problem that involves an incentive fee, that you may want to look at is Investment Company Act Release number 7113, that's dated April 6, 1972. Now, one of the interpretations, for example, is that the index that is selected must be comparable to the portfolio of the advisory client, in this case, the investment company portfolio. That is to say, if you are a general growth portfolio, for purposes of determining your incentive fee, you must pick an index, which is basically composed of securities representing that type of company. Or if, for example, you're an investment company that simply invests in aviation stocks, then your index, for purposes of determining the incentive fee, again, must be appropriate to that type of a portfolio. Also, we've taken the position that the performance period over which the charge is measured shall not be less than 1 year. We want to make sure that the performance that is being used on which to base the incentive fee is real performance, not simply performance of a month or 2 months or 3 months. That's why we picked the 1 year. Also, we've said that the fee shall be paid on the average net asset value over the year. You can't pick the highest net asset value of the investment company shares and pay your fee on that basis. Also, we've said that during the course of the year, the advisor should retain the lowest fee possible and specified in the contract. Now, the reason we've taken that position, again, this type of incentive fee is based upon performance. And until we see what the performance is going to be over the performance period, you really don't know what the final incentive fee is going to be, which the advisor will then be entitled to. In order to prevent the advisor from receiving a higher fee than he will end up being entitled to receive, we said that at any given time you should only take the lowest fee possible, specified in the contract.
In other words, if you started off with a fulcrum of a 0.5%, up a quarter, down a quarter, you would take a 1/4%, because you never could get less than a 1/4% in that fee arrangement. So you would be entitled to a 1/4%, and at the end of the year you would settle up.
Sid, what does that do to accounting, where you have to accrue the expenses daily? Do you think it just won't make enough of a difference to show up as a penny?
I think, as a matter of fact, the fund will probably show a contingent liability for the fulcrum fee.
So they'll charge the quarter.
During the period that's going on, while you don't pay the fee for accounting purposes, as I understand it. We have some accountants here involved. For accounting purposes, if the investment company is ahead of the index at any one time, it wouldn't be improper to show a possible contingent liability, or even a liability, a reserve. That reserve could be dissolved if the investment company, the index started to beat the investment company, and I think that's the way it's done. As I said, I myself have not sat through it, but I think that's the way it's done. And one of the people who has done some accounting in this area is nodding his head, so I assume that I'm right. But you see, the fund isn't going to lose a lot either way, because to the extent that its contingent liability is being dissipated, its performance is going down. So it's not a big gain or loss. It's to the fund's benefit to have a big contingent liability here.
Sid, let me ask you for one other interpretive question. We talk about the stock indexes, and I know in certain cases, maybe the aviation or the specialty stock fund, that they're really hard-pressed to come up with any index. And
Well, yes, they are, and this is one of the big problems in this whole area. Fortunately, right now we don't have this problem, although we may be getting it shortly again. Generally speaking, if in interpretations that have come to me, I have to, where there is no special index, say for aviation or tin cans or whatever, there is no index. I would then not object if they used an index which would be comparable to the type of securities that the fund is going into, even though they wouldn't be identical to the type of industry. For example, let me give you an example. If you had a go-go fund, it would definitely not be an appropriate to use use Dow Jones, which is a conservative blue chip type of index, and therefore to have a go-go fund buying speculative securities and measuring it against the Dow Jones index would be in any bull market would almost assure yourself that you'd beat the index, almost assure, because that index goes up slower than normally the speculative securities goes up. Conversely, it goes down slower in a bear market. But we have attempted, where this proposition has been given to us, to recognize that sometimes they're not identical indexes, where they're in specialties. And we would allow, for example, if aviation stock was a general growth stock, we would not object, for example, as I recall, for them to use Standard & Poor's or something of that sort.
let me give you one other hypothetical, and this also may not come up, but a balanced fund, which is basically a fund that's pretty much out of favor nowadays, but used to be the largest funds, which deviates between equity securities and bonds, depending on the advisor's sense of whether it's a period during which you can get high interest rates or a period during which equities will grow. And usually you don't get both together, although that can happen. Now, there's no index, as I understand it, that would really cover that. But would you take no action or not raise any point on an inspection if you had a balanced fund with a performance fee based on, let's say, half based on the Standard & Poor's 500 and half based on the Salomon Brothers bond index?
I would probably take. Let me say, and I don't want to be bound by this in case for FOIA purposes this tape is made public. I don't want to be bound, but from the facts that you have given me, which are not complete facts, I would say that a combination of the two indexes would make one appropriate index. For example, in a balanced fund, as you know, as I recall, at least 25% must be in one or the other of the securities. In other words, 75-25. And then you have 25% in bonds or 25% in equities, and the rest either in equities or bonds, depending, so that you have no worse a proportion than 75-25. Well, if it was 75-25, I would weight the two the bond index and the equity index. If it was 75% equity, I would weight it 75-25 and have a combined index for that purpose. and I would not. I don't think I would object to that type of index. I think I think the staff has to be elastic, if you will, to the legitimate activities of industry. I personally don't favor incentive fees, but I am not the giver of the law, and therefore I recognize that what the law is and what the Congress contemplated in doing it. And it seems to me they set it an appropriate index. It doesn't say the only appropriate index, so I think I would be inclined to give a no action in that situation.
I think your response has been appropriately conditioned, Sid.
Thank you.
The last point I wanted to make under this incentive fee is a point that Sid began to make, and that is whether it was the amendments of Section 205 plugging up that loophole, or what some of the skeptics among us would say, the down market of the 1970s. We have found that the number of investment companies that today have incentive fee provisions built into their investment advisory contracts is radically reduced from the number that we found in the late 1960s. Indeed, it is a very, very rare investment company that has today an incentive fee provision in their contract, although, as Sid notes, we have the last year seen more and more investment companies going into that contract, which, say, in the previous 2 or 3 years, we did not see any trend. Now we do see more and more investment companies adopting incentive fee contracts.
That's for two reasons. One reason is that it's hard. The very type of securities one buys to beat the index on the way up, generally speaking, could lead the industry on the way down. And therefore, in a bear market, incentive fees are not popular among investment advisors because it's very hard to beat the index when both of you are going down. Secondly, there is something almost insidious about getting an incentive fee for losing money, even though logically you're saying you lost less money than you could have lost had you followed the index exactly. It doesn't make for shareholders goodwill to say, I'm taking an extra fee because I lost less money for you this year than I possibly could have. It just doesn't go over well.
Sid, just as a footnote to that, there's the Vanguard complex of investment companies has been found to be, and it's a very unusual complex, in an administrative proceeding recently was found to be not controlled by their advisor. And in fact, their advisor they have several advisors, different funds have different advisors, and their boards are 100% independent of their advisors. And it's interesting to note that of those dozen or so funds, a majority of them have had incentive fees applied by the board. So at least in those cases where the advisor is really not controlling the board, although he doesn't have to accept the contract with the incentive fee, the board has in those cases asked for an incentive fee, and presumably thinking that was the best thing for investors.
It's a very interesting observation, and it's a very interesting phenomenon. As a matter of fact, another investment company who asked for a fee increase recently,
the Fidelity Complex,
was put on an incentive fee by its board because the board did not feel, as I understand it, that the performance of the investment companies was as good as it could have been, and therefore it put the Fidelity on an incentive fee so that if it doesn't perform better, the investment advisor stands to lose some money.
Yeah, if Arthur can put in a plug for the directors of one of his funds, let me put in a plug for one of mine, as Sidney was saying.
Glenn, before you go on, I'm not endorsing their action. I'm just trying to describe it.
Obviously, I wasn't being quoted when I said that. But when the Fidelity Complex did move last year to approve new investment advisory contracts with a modification upward of their advisory fee, pursuant to their 15C review relating back to what we discussed before, the independent directors, before approving that advisory fee index, did insist that the advisor agree to inclusion of an incentive fee provision in the Fidelity contracts.
Well, as long as you're throwing accolades at that board, I think it only appropriate that we note that the staff was breathing very hotly down the neck of that board when it was reviewing the contract. And I think we ought to state also that that wasn't the first contract that came in.
Also, in that case, wasn't the fulcrum fee higher than the old fee?
As I say, that was pursuant to an increase in the fee.
Yes.
That's right. And as one that deals with Fidelity quite often, I realize the heat that can be brought to bear and the results that can have.
It was just a suggestion by the staff as they reviewed it.
And of course, you know what the power of suggestion is. That then is the provisions of Section 15 with reference to Section 205 as it relates to the incentive fee provision as they relate to approval of investment advisory contracts. Let me just spend a very few minutes and discuss the procedure under Section 15 that must be followed in approval of contracts between investment companies and their principal underwriters. First of all, let me just note quickly that the definition of principal underwriter is contained in Section 2A29 of the Investment Company Act, and it differs from the general definition of underwriter, both for purposes of Section 2A40 of the Investment Company Act and also the definition of underwriter in the 33 Act, since the 2A40 is almost verbatim from the 33 Act definition of underwriter. Section 15B only applies to contracts between investment companies and their principal underwriters. So you want to take a look at Section 2A29 and make sure that before you question whether or not an underwriting contract had to comply with Section 15, that we're talking about a principal underwriter relationship. Section 15B specifies that a contract between a registered investment company and a principal underwriter must be approved by a majority of the directors of the investment company. First thing to note here is the distinction between 15B and 15A, in that 15A requires approval of a majority of the outstanding securities in order to approve an advisory contract, while under 15B you only have to get approval of a majority of the directors. 15B also specifies that a contract between an investment company and a principal underwriter can continue for 2 years from the date of execution. And then continuance of the contract can only be effected if it is approved annually by the board of directors or a majority of the outstanding voting securities. Again, that provision is identical to the continuation provision that exists in Section 15A for advisory contracts. Also, 15B includes the provision requiring that a principal underwriter contract automatically terminate on assignment. Let me add that because this automatic termination on assignment provision is included in 15B, proposed Rule 2A6 dealing with what constitutes an assignment also will apply, if it is adopted, to contracts between investment companies and principal underwriters. Also, dealing with the issue of when a principal underwriter contract and how a principal underwriter contract should be continued, Rule 15A2, dealing with timing of voting of continuation of advisory contracts, also applies to continuation of underwriter contracts. So as long as you vote to continue a principal underwriting contract within 90 days before its termination, that will be an appropriate vote to continue the underwriting contract.
Now, the principal difference is that you don't have to go to shareholders for an underwriting contract. Isn't that correct?
That's right. That's why maybe it is good just to clarify that point. While proposed Rule 2A6 will apply to principal underwriter transactions, you don't have the problem with an assignment in the underwriter area than you have in the advisory area, because, as Sidney notes, and as I noted, the key distinction is, in the advisory area, you have to have the contract voted on and approved by shareholders, while you don't have to have that approval in the underwriting area. Therefore, there should be no problem in terms of scheduling an assignment. That is to say, there should be no problem with being able to call a meeting of your board of directors, quickly convene the meeting, and then have the directors approve a new underwriting agreement. While, of course, there is quite a bit of a problem if you're talking in terms of calling a shareholders meeting, drafting proxy material, and getting that all out in the context of approval of a new advisory agreement. For that reason, we have not had the filing of applications requesting exemptions from the provisions of 15B.
Actually, we have.
To deal with the underwriter situation. I find I'm being corrected, properly so, that we have had a few. I overstated that, but we have not had either the volume of applications in the underwriting area, and it has not been the problem that it has been under Section 15A.
I think the industry has changed in the last 10 or 15 years. Underwriting the distribution of securities of investment companies is not a profitable venture. It's a losing venture. So as a result of that, most investment advisors own the distributor. And as far as the investment advisor is concerned, the expenses of the distributor are taken in as the expenses of obtaining the investment advisory contract.
Sid, I think what you say goes a long way in explaining why the statute, at least in a practical sense, doesn't require shareholders to consider this underwriting contract. Really, that it's an action that the fund has to take if they need an underwriter, but the shareholders aren't involved. Are there any other reasons why is really just left to directors? Shareholders don't need to have a say here.
The main reason, as I see it, the main reason is that an underwriting contract is a direct cost of the investment advisor. I mean, of the investment company. In other words, the charges, not the underwriter, the investment advisory contract. The fee is taken out of the corpus of the fund. The fee normally in an underwriting contract is paid for by the shareholder entering or purchasing the shares. The load is borne by him, and up until this point at least, the fund does not bear the cost of distribution directly.
So there's no consideration being paid by the fund to the underwriter for him to take on this task.
And that was the way it was normally, and it remains so today. At least the payments are not made directly.
That's an important point, and I think aside from the requirements, technical requirements of 15B, you ought to understand why there's a difference between 15A and 15B. The final point I would want to make on the underwriting contract approval is that the provision of 15C requiring approval of a majority of the disinterested directors also applies to underwriting agreements. So your agreements between principal underwriters and investment companies also have to be approved by a majority of the disinterested directors. But for the reasons Sidney indicated as to why there is no need for shareholder approval. 15C, in putting the duties that we discussed before on directors to ask for and evaluate information ancillary to their approval of the advisory agreements, there is no comparable provision in the underwriting area. So there is no explicit duty in 15C for the disinterested directors to ask for or approve information in approving principal underwriter agreements. However, if the staff was presented with a case and if an inspection disclosed facts whereby directors simply cavalierly approved a principal underwriter agreement without giving any consideration at all to the merits of that agreement, and that agreement was clearly disadvantageous to the investment company, or was clearly phrased in such a way as to be in the interest of the underwriter as opposed to the interest of the investment company, even though there would be no 15C duty we could rely on, no doubt there would be a problem under Section 36A. Again, I won't go into the 36A provision since that will be covered later on, but the point I wanted to leave with you, even though there is no 15C duty for principal underwriters, you should bear in mind that the disinterested director approval of those contracts also has to meet the fiduciary duty standards of Section 36A. That then is the provisions of Section 15 as they apply both to the approval of investment advisory agreements and principal underwriter agreements. Are there any general questions? With that then, we will then go on to an analysis of the provisions of Section 17 to see what the provisions of the Act are as they govern transactions between investment companies and affiliated persons.
Now, we'll discuss that in detail in the next tape. The point that I would like to make here is that when you consider Section 17, consider the fact that the Congress has made Section 17 very much like trust law. Most of the things prohibited by Section 17 are the very things that a trustee would be prohibited from doing. It has, in effect, given to the Commission the same or similar duties that a court of equity would have when a trustee would come before that court, and ask for permission to do what would normally be a prohibited transaction. If you keep that in mind, that the affiliated persons that Howie will mention here are in the same general arena as trustees, you will get an understanding as to why this statute has the provisions that are incorporated in Section 17. Thank you.